Dear learners, welcome back to your educational channel Learn and Educate, where we were studying a few basics about the goods and service tax. Continuing that series, section 2, clause 79, non-taxable territory. As when a law is enacted, there is a jurisdiction up to which it is applicable. In the case of a state Goods and Service Tax Act, it is applicable to that particular state's jurisdiction only. When in the case of a union territory goods and service tax, when enacted, it is applicable to the jurisdiction area of that particular state only. In the case of supply within that union territory, it can levy tax. The few Union Territory Goods and Service Tax Act are passed in Lakshadweep, Daman and Diu, Dadra and Nagar Haveli, Chandigarh, Andaman and Nicobar Islands, Ladakh, Union Territory, and others. Chandigarh and other territory. So it can levy tax upon the transaction took place within the same Union Territory, intra-state transactions. Therefore, there has been differences between that applicable territory. Likewise, as the act passed by Parliament as integrated goods and service tax, it shall extend to the whole of India. As India has a three-tier federal structure comprising of the union government, state government, and local government, every government has the power to enact an act, to form an act, and levy, collect tax which are taking place in the taxable territory. Therefore, non-taxable territory are the territory which are outside the taxable territory of its jurisdiction. Taxable jurisdiction determines whether the transaction which took place on which that act, that government can levy and collect the taxes on the supply of goods or services or both. Therefore, non-taxable territory is a territory which is outside the taxable territory. The area, the territory which is beyond the scope of the taxable territory would be non-taxable territory under Central Goods and Service Tax Act 2017.